Okay, in this brief video, I'm going to be talking a little bit about how the fair use doctrine applies in relation to computers and various other materials distributed over the internet. Obviously, everything's done on computers these days, so this is a pretty salient question and one that courts, frankly, are really wrestling with how to figure out. So they're looking at fair use related questions related to copying of copyright protected materials in relation to the traditional fair use factors, right, and the basic principles behind fair use, but in many cases finding it difficult to find a one-to-one correspondence between those principles and the materials that they're in the position of needing to evaluate. In any case, we got two different examples of recent cases in the casebook that we're going to talk about. But I just wanted to point really briefly to the discussion that the book had of some other cases, and in particular, how to think about the concept of transformativeness when it comes to the use of copyrighted materials in computer programs. And really the key question that is novel around the way a lot of copyright protected works get used in a computer digital online context is that oftentimes what the alleged infringers are trying to do is to add functionality to a particular product or to users' ability to utilize those copyright protected works. And the question really is, when is that new kind of functionality protected and when is it not protected? And how should we think about those kinds of goals from a big picture practical sense, right? So historical cases involve, for example, a lot of search engine type cases. In many cases, Google was the subject of infringement actions on the grounds that many of its different services arguably violated the copyright protection of some of the works that it was referencing. So for example, when you use a Google image search provides to you thumbnail images of the different images available on the internet that might satisfy the search query that you've entered. In doing so, it's creating a representation of the image in question and presenting it to you. And from the copyright owner's perspective, that can be characterized as an infringing use, right? They're reproducing a copyright protected image on their own website, not where the owner of that copyrighted work put it. That seems on one level like a prima facie infringement, but on the other hand, how would Google image search work without it, right? Google image search is a really valuable and useful tool. People enjoy using it. And so the question is, if Google can't engage in some limited amount of copying of images on the internet in order to make its image search engine work, that's going to make consumers a lot less well off because Google image search is valuable to them. And that seems like a problem. Okay, another case was the Google Books case, where Google teamed up with a bunch of research libraries to create scanned versions of the books in the libraries. And a group of authors and publishers really brought infringement actions against Google and the libraries as well, alleging that this constituted infringement of their copyright protected works, like scanning the works and then making them available in different kinds of formats on the internet. And on one level, it seems like it's true, right? I mean, Google did in fact scan the entire book and did in fact scan the entire book into its database. That's a reproduction of the work without permission. And then making it available to users is another reproduction or display of the work in question to Google Book searchers. However, in the Google Book search case, rather than presenting the entire work, Google's search engine, as you may have noticed using the product, only provided snippets from the book to enable users to determine whether or not the book in question included language that was relevant to the search query that they'd entered. And the court ultimately held that was a transformative use, because what Google was doing was providing utility to users who wanted to know something about the book in question, not providing a substitute for the book itself. In other words, you couldn't use Google image search to read the entire book, unless, of course, the book was in the public domain, in which case Google would just present you with the entire book, and that wasn't a problem. If it was a copyright protected book, right? The only part that you could get through the Google book search was snippets showing the materials that you'd actually search for that wouldn't enable you to consume the entire book. Therefore, the image search wasn't a substitute for the book. It was providing a new utility that made the book more useful. Well, that's kind of relevant to what was going on in the Fox News v. TV Eyes case, right? So TV Eyes was essentially providing a service that enabled users to search through television materials and find the materials that they were looking for and then watch them online. So it's a very convenient service that its customers could use in order to search through television news footage and find the material that was relevant to what they were doing. And really it was targeted primarily at journalists and others in the content production business who are looking to put together their own materials and needed to be able to find what was already out there in order to do so. And Fox News brought an infringement action against them, alleging that the service violated copyright protection. And the lower court kind of issued a mixed ruling, right? They said that some of the things that TV Eyes was doing, like allowing people to download the entire content or to watch television shows on the basis of when they were programmed as opposed to the material that they contained, were arguably infringing, but that other aspects of the service were not, specifically that enabling users to search the television news content for particular keywords was not infringing because it was a transformative use, right? You weren't, as a user, you weren't using the program in order to just watch the news. You were using the program in order to find particular kinds of content. It's the echoes of the Google Books case there. The Second Circuit then reversed, however, right? And it did so, I would argue, primarily on the basis that it said, look, this is a service that Fox News could be providing. All you're doing is you're taking Fox News content and you're marketing that content to your customers. You're asking them to pay you so that you provide a service for searching through Fox News content. Is that transformative? It says no, you're just showing them the same material that's already available, right? Is the material the kind of material that is protected by copyright? Sure, even though it's news, it was still created by Fox News. They put their spin on it, that's fine, right? How much are you using? Well, you're using all of it with respect to what the customer actually wants. And I think critically, are you infringing on their market? And the court says, sure, you absolutely are. Fox News could be selling this content, not you. And therefore, the use that you're making of it is indeed infringing. Now, side note, Fox News doesn't really provide the service itself. Does that matter for the purpose of the infringement analysis, right? It kind of leaves users in the lurch, right? This is a useful service. Shouldn't somebody be providing it? And if Fox News isn't providing it, then do we want to say that somebody else can't? Incidentally, there's also a service provided by Vanderbilt Library called the Vanderbilt Television News Archive, which in many respects is quite similar. However, it's not provided online, right? So you can search through an online database by keywords. If you find a segment that looks like it would be interesting, you can then contact Vanderbilt, which will lend you a copy of the video. And that's actually protected explicitly in the Copyright Act, right? Effectively, the Vanderbilt Television News Archive was written in to the Copyright Act by Congress, but it was done long before the invention of, or public availability of anyway, the internet. And it's not very convenient. The TV Eyes service was way more convenient. Don't we want this material available for people to use in an effective, efficient, productive way? And if it's not available, is that a problem? And should it affect our fair use analysis in any way? Okay, we can also look at the Google v. Oracle case. This was a giant Supreme Court case from quite recently. And what it boiled down to was Oracle, the owner of the programming language, Java, right? They created Java, which is a very widely used programming language. Google wanted to create its own Oracle operating system for cell phones, and it wanted that operating system to be familiar and usable by the widest range of programmers possible. And in order to do so, it needed to use something called APIs, which are effectively like subroutines that are used by programmers to kind of mechanically enable software to do things. And they need to be kind of essentially like portable from one system to another, because programmers who've used Java know how to use APIs in Java, and you don't want to force them to learn an entirely new ecosystem in order to do their programming. So Google selectively copied from Java into Android the APIs that it needed in order to make its new programming language familiar to its customers, essentially programmers who are going to be using the Android system in order to produce products for consumers. There was a lot of back and forth between the lower courts and the district court and the federal circuit. Ultimately, two questions arose. First off, could APIs be protectable in the first place? Are they copyrightable subject matter, or are they functional elements of the computer programs that are outside the scope of copyright protection? And second, if they could be protected, then was Google's use of Oracle's Java APIs, was it a fair use? And the Supreme Court ultimately said, well, we're not going to answer the first question. We're going to set that aside. But for the purpose of argument, right, we're going to assume that it is copyrightable subject matter, although we're not actually saying it is. It might not be. But if it is copyrightable subject matter, essentially the Supreme Court concluded it's still a fair use. Well, why is that? Kind of mixes up the factors a little bit in an interesting way. It starts by asking, what's the nature of the material in question in the first place, right? It says, well, this is a computer program, and more than that, it's kind of like very functional aspects of a computer program. It's the aspects of the computer program that sort of make it work at the very basic level. So if it's protected, it's not protected very much, right? We need to be really careful about the scope of copyright protection here, because we don't want it to be too excessive. And then it goes through the other factors as well, right? Finding in each case in favor of Google on the fair use question, right? So it says, well, how much did they copy? Well, on one level, they copied all of the APIs that were ported into Android, but that was only a small part of Google's program. And also it was only a small part of Java, right? They copied only as much as they needed to in order to make the program actually function. The Supreme Court says that's the kind of quantity of use that's consistent with the fair use doctrine. Right? They didn't use more than they needed to. They used just as much as was necessary to accomplish their goal. Was it transformative? Well, it was transformative in the sense that it used these APIs to achieve a goal that was valuable to consumers. Ultimately, whether consumers, programmers, or consumers using the new software created by those programmers, right? Is that transformative? Well, it's socially beneficial. Maybe that's what we mean by transformative, right? And then finally, it asked, is there a market effect? And it essentially what the Supreme Court pointed to was the reality that depending on how you define the nature of the market and the nature of the use, you can either find that there's a market effect or there isn't. Here, if Google had been forced to pay for the use of the APIs, then that would have a market effect, right? But the question is it a market effect on the relevant market, right? In other words, is this actually harming Oracle and its Java product, or is it ultimately beneficial to have this all built out together? And essentially, the court looks at the relationship between the Java language and the new Google Android language and says, look, the entire point here was to maintain a unified universe that programmers could work in. We don't really see that as being a relevant market harm to Oracle. Therefore, on the whole, across the board, this is going to be a fair use.